this is Peter. Hello, this is Peter.
Okay, Shannon, put us on the record.
Okay.
Okay, this is a matter of Bournemouth versus City of Jackson et al.
Yeah, the meeting.
Do either of you know if anyone else is planning on participating?
I am not aware of anyone else, Your Honor. Audrey Forbush for the defendants.
Okay, Mr. Bournemouth, your microphone is muted.
993 793.
I don't know of anyone else either, Your Honor. Thank you.
Okay, I didn't see any other party names in the waiting room. Let me make sure of that. I have one person logged in, excuse me, on a device that they didn't plug their name in. I'm going to assume they are not on this case. So I see there are two motions up today, two competing motions for protective order. Before I go any farther, Ms. Forbush, I do need to disclose Mr. Bournemouth and I are acquainted. We're not personal friends, but years ago, we played basketball together at the Y, and I bumped into him occasionally, quite literally, a couple winters back. But I don't have any issues one way or the other. I think I can treat Mr. Bournemouth fairly. I can treat all of the defendants fairly, but I want to disclose that. I don't, and if you, after consulting with your clients, if any of them have any issue with that, just speak up and let me know. I've presided over at least one other case with Mr. Bournemouth, maybe two. And disclosed, and in that case, there was no objection to me moving forward. So anyway, is there any objection this morning with respect to the motions that are before me, Ms. Forbush?
Your Honor, I will pass along your statements to my clients, but I don't anticipate any problems. I've appeared before you before. I'm assuming you will be the same unbiased jurist that you've always been.
Okay. So the two motions that are in front of me, the defendants want me to prohibit Mr. Bournemouth from inquiring into the religious beliefs of the defendants, the individual defendants, and Mr. Bournemouth wants me to prohibit you from prying into his personal finances. I read both of your briefs, and I will give you time to make additional arguments if you think you need to. But my mindset on the two issues is the way I read the authority with respect to limits on inquiring into religious beliefs of witnesses is if you're doing it to try to somehow impact their credibility as a witness. We've got a case here that involves allegations of religious discrimination. Why, Ms. Forbush, isn't it appropriate, at least for Mr. Bournemouth, to make some inquiry as to what the religious beliefs of the individual decision makers might be? Doesn't that have some potential bearing on whether or not they're disposed to discriminate against Mr. Bournemouth because he has differing religious beliefs?
Your Honor, I think it does have some probative value, of course. And However, what concerns me are representations that have been made by Mr. Bormuth, such as Christianity is the single most evil, repressive, and reactionary force in recorded human history. And he's been abusive and somewhat threatening in public meetings. He's made clear his aversion to evil Christian Jesus scum on numerous occasions. And I just want to put some limits in place. Certainly if he, I think he already knows, but if he wants to ask, as he indicated with regard to Arlene Robinson about the standards he applied when determining the most qualified candidate. And if he wants to ask a limited question with regard to whether Christianity was a factor or not, that's one thing. But to allow him to potentially explore in more detail her religious beliefs, given his rather threatening tone in some of his emails and some of his public statements, we want to bring that to a head and to make sure that these depositions don't become a pulpit for Bormuth. In his response, he indicated, hey, look, I want to impeach Derek Dobies with regard to prior consistent statements. That's absolutely fair. He wants to question, Ms. Robinson about what standards she applies. When he talks about Ms. Bonnell, the individual who was appointed to the position, he points to an email where he responded to him, his questions regarding her religion, and she responded, yeah, I grew up in a Christian home. I support some Christian values. Enough, period. If he wanted to ask if any of the voting members questioned her about her religious preference, I think that's fine. But to allow us to go down this road of what her specific religious beliefs are or her specific religious practices are, I think invades, the province of the court rules and the statute, and becomes abusive and harassing. And we just want the parameters set for the deposition so that we don't have to adjourn them or revisit questions down the road.
So, based on the way Mr. Bormuth has conducted himself in the two prior cases that I preside over, I don't believe that he is going to step outside of the bounds of what would be an appropriate inquiry. But I will tell you, Mr. Bormuth, I don't want you attacking any of these witnesses because of their religious beliefs. You could certainly
I would never do that.
You could certainly respectfully inquire in a limited fashion, and I think that's appropriate. Ms. Forbush, if Mr. Bormuth should behave contrary to what he's indicating and what I frankly believe from my past experience in litigation, you certainly at that point could stop the deposition and bring it back in front of me. I don't think you're going to have a problem, but as long as we're clear on those ground rules, I think some limited inquiry into how the individual religious beliefs of the decision makers. I don't know if the successful candidate is one of the deponents. The fact of what her religious beliefs are, but she was not a decision maker. She was a successful candidate. So obviously the inquiry there needs to be far more limited. But if he wants to establish at a deposition for the record that she holds Christian beliefs or whatever it is that she does, that's an appropriate question for him to ask. Because, I mean, in a normal case, it wouldn't be. But because we have a case of religious discrimination, I think it's a fair area of inquiry. And as long as he does that respectfully, I don't have a problem with him inquiring about that. So let's
Your Honor,
Did you have a further question?
just to clarify, I'm assuming I have to submit some type of order with regard to our motion. Is there a particular language that the court would like me to submit with regard to our order?
Actually, all you need to put in your order is, for the reasons stated on the record, defendant's motion is denied. But Mr. Bournemouth is here. He's heard what I've had to say. I don't think I need to put it in an order. I'm giving you some guidelines if things should go astray at a deposition. And you can absolutely act to protect the witnesses if Mr. Bournemouth should get out of hand with his questions.
Thank you.
All right, so let's turn to Mr. Bournemouth's motion, which deals with not wanting you to pry into his finances. So, Mr. Bournemouth, because you've made an employment discrimination claim, one of the defenses to a employment discrimination claim bears on failure to mitigate damages. And I used to practice employment litigation, so this is an area I'm very familiar with. A plaintiff in an employment discrimination case has a duty to mitigate damages that would flow from denied or lost employment. In virtually every employment discrimination case I was ever involved in, there was always inquiry into whatever income is earned essentially post-claim to see if you've satisfied your duty to mitigate damages. I can't bar inquiry into your personal finances unless you were to drop your claim for lost wages. If you willingly withdrew your claim for lost wages, and I'll give Ms. Forbush a chance to speak to this, I don't think at that point they'd have any reason to look into your personal finances.
Your Honor, in their brief, they suggested 3 reasons why they should have access to that information. The first was that as a public official, my taxes would, of course, be open to the public, but I didn't get appointed. I'm still a private individual, so I didn't feel like that had any merit. Then they said, as part of the qualification for public office, an individual must sign an attestation that they're not in default to the city. The statute, the ordinance gives you 30 days after appointment to take care of that issue. So I didn't feel like that was pertinent either. And then finally, they said the plaintiff could have monetary sanctions imposed against him in this matter for a frivolous lawsuit. I sent your clerk an exhibit I'd like to enter into the record at this point. And it's from the Equal Opportunity Employment Commission, Section 12, Religious Discrimination website. And there's an example on there of hiring. And it basically suggests that, you know, in this case, I'll read it to you, I guess, into the record. Hiring, Mary is a human resource officer who is filling a vacant administrative position at a company. During the application process, she performs an internet search on the candidates and learns the one applicant, Jonathan, has written an article for the local chapter of the Ethical Society, setting forth his views that religion has been historically divisive and explaining why he subscribes to no religious beliefs or practices. Although Mary believes he is the most qualified candidate, she does not hire him because she knows that many of the current company employees are observant Christians like her, and she believes they would be more comfortable working with someone like-minded. By not hiring Jonathan because of his lack of religious identification, the company has violated Title VII. So I changed the language just slightly to make it adapt to this case. Arlene is a city council person who is voting to fill a vacant seat on the city council. During the application process, she performs the internet search on the candidates and learns that one applicant, Peter, has written emails setting forth his views that the Christian religion has been historically divisive and evil, and explaining why he subscribes to pagan beliefs and practices. Although Arlene believes he is the most qualified candidate, she does not vote for him because she knows that many current city employees are observant Christians like her, and she believes they would be more comfortable working with someone like-minded. By not hiring Peter because of his lack of a Christian identification, the city violates Title VII. Now, my lawsuit can't be frivolous. I mean, it's possible that the facts unearthed during depositions do not, fill in.
Mr. Bournemouth, let me stop you. I was wondering where you were going with this, and I understand now. I would not allow inquiry into your finances or assets solely for the purpose of finding out if you have the ability to satisfy a sanction claim. That's not an appropriate basis for discovery. You don't need to worry about that.
Okay, thank you.
The problem really is the fact that you've got a claim for lost wages, essentially, and the affirmative defense certainly allows inquiry into what you've done to mitigate your damages. So as long as you have a claim for lost wages, it's appropriate for them to inquire into your earnings.
No problem, Your Honor.
So for that reason, and not for the other reasons that were given, I'm going to deny your motion.
Okay, Your Honor.
For the reasons stated on the record. And Ms. Forbush, if you wouldn't mind, you could put both of these in one order. For the reasons stated on the record, both plaintiffs and defendants' motions for a protective order are denied. But I've given you some parameters. I don't anticipate you're going to have problems, but if you do, you know how to get my attention.
Thank you, Your Honor. I appreciate it.
You're welcome.
Thank you, Your Honor.
Welcome. Have a good day.
Thank
You too, Your Honor.
Let's see. Mr. McCord. Good morning, Mr. McCord. This is a matter of Fadia versus Buffy et al. I'm looking to see if there's any one with any of the defendants' names. I have one device I'm going to have to bring in and find out who it is. None of the other people identified who've put their identity in appear as defendants. Because this is a request for a default judgment, I don't anticipate that anybody would be appearing.
Right.
But let me just make sure. As soon as we get an audio connection, we'll find out who this is. Okay, it looks like I have a, well, no, I don't. It says it was connected and then it started. Let's try again. All right, someone I just allowed into my courtroom with it's just identified as the Galaxy device. Could you unmute your microphone and tell me who you are?
Yeah, this is William Stein with Stein Timber.
All right, can you turn your volume up a little? I cannot hear you. It's William, last name again?
Trine, Trine.
All right, I'm going to put you back in the waiting room. I had called a case and I wanted to see if you were a party on that case. You're not. But now I'll know when it is time to call you back in who you are. So I'm going to put you back in the waiting room.
So they have,
Okay, Mr. McCord, you are seeking a default judgment. Is this a property case?
It's an action to quiet title, Your Honor.
All right. Publication was achieved, or service was achieved by publication. No one has filed any opposition, and no one has appeared today to oppose your request. I will grant your request. You may submit a judgment.
There should be one. I did submit a proposed judgment along with the motion. It's as Exhibit A.
All right, hold on. It's not in my file, but let me see if it's if it's been scanned.
Or I can scan and email over another one if that's easier.
Give me just a second. All right, I see it. I'll have print it out and sign it and make sure it's furnished to you. All right, Peter, I'm just going to print the whole thing. It doesn't allow me to select pages.
Okay.
All right, I'll be signing that and grant you your judgment.
Very good. Thank you, Judge.
You're welcome. Okay, and let's see. Looks like another default. All right, this is the matter of Kerwa, Michigan LLC versus Patriot Manufacturing. Counsel, state your appearance.
Yes, Your Honor. David Bowen, appearing on behalf of Kerwa, Michigan LLC.
Okay, and I'm looking, you've got two corporate, or a corporate defendant rather. No one has filed an appearance. I don't know who, let's see, I've got a resident agent. Let me check and see if there's anybody by that name in the waiting room. And I do not see anyone. You're requesting a default judgment today?
Yes, Your Honor. I've provided a proposed judgment. And again, the defendant in this matter, Patriot Homes, actually had filed bankruptcy and no longer exists as an entity. And so under the court rules, there is a service of process is done upon the resident agent, being the state of Michigan. They were registered to do business in the state of Michigan, and after the bankruptcy, have no longer validly done business in Michigan. So that service of process took place upon the appropriate agency with the state of Michigan.
And is this a quiet title action or?
In a sense, it's a quiet, yes, it is to actually, it is an action. This order that is proposed will be provided to the Secretary of State's office in order to issue a title. At the time that this manufactured home was placed on the property in question, the chain of title indicates that the make, model, and serial number of this home as being attached to it, referenced in mortgages and other documents, but no title was ever issued by the state of Michigan. And the law since 1978 has always been that these manufacturers were supposed to obtain a title and then an affidavit of a fixture done. So this is a process of getting a title issued by the state of Michigan, then an affidavit of a fixture. And so it's a quiet title action in that sense of attaching it to the property legally.
All right, and I have found the proposed default judgment. There being no opposition to it, I'm going to grant it.
I appreciate that. Thank you, Your Honor.
You're welcome. Have a good day. I just sent that, or I'm sending that to print as well. Okay, let's see. What do we got next? Panhandle versus Loud. Bless you. Bless you. Good morning, gentlemen. This is a matter of Panhandle Eastern Pipeline Company versus Loud.
Good morning, Your Honor.
Let's see. I know we've got at least one party here. I think.
Good morning, Your Honor.
See.
Bill Horn appearing on behalf of Panhandle.
And Rod Dunlap appearing on behalf of the Louds. Yeah, I think, Your Honor, at least Mary Loud Neff and James Gray are also in the waiting room. James Gray's our expert, and then Mary is one of the owners of the property.
All right, they're both there. I'm letting them in.
And these are the defendants?
And Your Honor, Nathan.
I'll find out shortly, Shannon.
Dan might
Your
also.
Honor, Nathan Cloud.
Nathan Cloud, okay, I'm letting him in. All right, and I've got someone in the waiting room. It just says Pauline's iPad. Is there a Pauline involved in this case?
I don't know about that, Your Honor.
This is Mary Neff. Pauline is Kenneth Loud's wife. They are dialed in.
Okay.
Oh, okay.
Thanks,
Good.
Your Honor. Appreciate that.
All right. Well, the only person remaining in my waiting room is an attorney on another case. So I think all of you present are on this file. So let's see. Mr. Horn represents the plaintiff, and which of the persons in the courtroom are your client representatives, Mr. Horn?
Mr. Nathan Cloud, Your Honor.
Did you get that, Shannon?
Yep.
Okay, thank you. And as to, well, let's hold on. Looks like Mr. Gray's having trouble with his connection. Can you hear me, Mr. Gray?
Fine, I was just changing positions, but I'm all is well here.
No, I was getting a little signal on the screen about a audio connection, but I see that's gone now. All right, then let's see. Mr. Dunlap, you represent all of the defendants?
That's correct, Your Honor.
All right, and I see a number of individuals in the courtroom. Could you identify each of them, please, just for the record?
Sure, Your Honor. Myself, Rod Dunlap, and then you have Mary Neff, who's present. Her husband, Stan Neff, and Mary is Mary Cloud Neff, or Mary Loud Neff. And then we also have Kenneth Loud is available. James Gray is the person who's also here on our behalf, and he's an expert in logging and land management.
Okay.
Echo. It isn't loud enough. I'm just getting echoes.
All right. So,
machines on.
So, Mr. Horn, this is your motion?
That's right, Your Honor. Just a preliminary matter, I submitted 12 exhibits to your clerk, potential exhibits. I want to make sure you received them.
Those are your email because they're colored photos.
Okay, hold on, let me pull those up.
It should be right at the top.
I did get them too, by the way, Bill, yesterday. Thank you.
All right, good.
Who's that guy?
Other person's attorney.
Okay, I have those exhibits. You may proceed, Mr. Horn.
Thank you, Your Honor. We have submitted the affidavit of Nathan Cloud in support of the motion. I have Mr. Cloud here today to present testimony if you would like.
Well, let me hear some argument first to see whether or not there's going to be a need for testimony. I understand your position that the moving of heavy equipment over this easement has the potential to damage the cause damage to the pipeline. So if there was a response filed, I haven't seen it. So let me hear from defense counsel as to what you believe the facts will establish.
Yeah, you should have a response, Your Honor. Can you check to make sure you have that? Because we did file that yesterday.
I don't doubt that, but it hasn't made its way to the court file. So why don't you just tell me? Why don't you just tell me what your response is?
Absolutely. Okay, this is a 78-year-old right-of-way easement. And part of what's important in this easement is the language that we have attached and blown up. If you look at the exhibits that he filed, I think if you look at Exhibit A that Mr. Horn attached yesterday, do you have those exhibits in front of you?
I see the right-of-way grant, plaintiff's
Yes.
Exhibit A. I have it open on my computer.
All right, so if you look at that document, I read some significant language, which I believe is in the second page of that document. And this is what I think is operative of this whole case. So the fact of the matter is that this has been around for 78 years. And the fact of the matter is that it is up to the grantee, it's up to Panhandle Eastern to make sure that the pipe is laid at a sufficient level, and it's up to them not to interfere with the cultivation of the land by my clients. So, and I attached the language in here, but let me just read that portion that I think is significant of the of the agreement that's not included in Mr. Horn's brief. So it does say that all pipe laid under this grant shall be buried to a proper depth so as not to interfere with the ordinary cultivation of said lands of the theretofore established drainage systems thereon. So it's initially their burden to show that the pipe is of the right depth. It goes on to say that the grantee, that being Panhandle, further agrees to pay all damage which may arise to crops and fences of grantor caused by the laying, maintaining, replacing, or removing of said pipeline or lines. And again, it's their burden to make sure that they're not interfering. And for 78 years, they haven't interfered. And for 78 years, my client has had lumber removed from the property. And for 78 years, it's been farmed. And if you look at the photographs that Mr. Horn has attached, it's quite obvious that that property is being farmed this year and as it has been for decades. And it's up to them to make sure that the pipe is of the right, is not a problem. Now, we've tried to work with them as the cultivation was occurring. Trine Lumber is out there doing the work and they're doing what they can. And then what has happened is that Mr. Horn's client has come in and said, you can't do anything, just stop. Well, stopping is not what's provided under the contract, and they have to provide a reason for it. Now, my understanding is they've constructed an air bridge, which is fine. So if you have an air bridge or you have something in order to allow them to cross along that property, tell us what the size is that you're going to allow us to move over. And there's nothing that's been done to that effect. So it's okay. Nobody wants to cause any damage here. But on the other hand, the damage and the burden is on Panhandle to show that they're not interfering with their property. And all they've done for the last month is interfere. They have not provided a means of there's any basis for that. There's nothing attached to their brief. There's nothing to show that there's something that we have to do. I mean, we have multiple axles on the logging trucks that are being used, and that means that there's not as much of a weight that's going to go across that pipeline. The pipeline goes across the entire length of the property. Cultivation equipment goes across that property all the time, like it has for 78 years. They have provided no guidelines saying this is what we want you to do or not want you to do. And then it's interesting, if you look further into this agreement, it says that if there's a disagreement as to how much they have to pay for interfering with their property, there's an appraisal and an arbitration means that's provided, where if both sides can't agree on how much they owe us, a third person is appointed to make that determination. So all they've done is tell us no and then go to court. They've provided no means of saying this is what you can do to properly take lumber from the property like you have for years. So we have a real concern with that, Your Honor. And we also want to make sure that a preliminary injunction doesn't stop the farming that's been going on in that property. So this is impacting Trine Lumber, who has a contract to do this. It also could impact the farmland there with Lincoln Farms. And now we have an issue of a Right to Farm Act issue. There's a right to farm, and there's been farming that's been going on in that property for a long time. And their position is to just say no. Now, I understand they've got a pipeline, and there's pipeline across the state, there's pipeline all over the country. But you can't just say I have a pipeline, therefore stop. You have to provide a means for us to conduct the cultivation on the property, to get the lumber off the property. This is what they failed to do. This is what the basis of our argument is, and this is why we're asking that it be highly restricted, specific, or just that this motion be denied in general, because they have not provided any guidelines for it.
My understanding of the motion was the only thing that they're asking me to restrict is driving these fully loaded logging trucks over the pipeline. They're not asking that we do anything to stop the harvesting of crops or the cultivation of the field. Am I correct on that, Mr. Horn?
Yes, Your Honor, you're correct. We are not trying to stop any cultivation. In fact, if you look at proposed Exhibit D, it's an aerial photo showing that they have cultivated corn on that property and harvested it. We didn't stop them. We aren't seeking an order stopping them from logging. All we want is that the crossing of the pipelines by these heavy trucks stop, or that they should have put in, as we requested, an air bridge to protect the pipelines. That's all we're asking.
what exactly is an air bridge?
Your Honor, if you turn to potential exhibit E and F, it's basically a means of crossing the pipeline with heavy wooden lumber put down that disperses the weight of the vehicles when they go over the top of the pipelines. And
what is the threshold of axle weight that poses potential for damage to the pipeline?
According to calculations Mr. Cloud has made, anything over 5,000 pounds axle weight creates a risk to the pipeline.
Well, I gotta believe tractors and combines and other harvesting equipment are more than 5,000 pounds per axle weight. Are they not?
They are different configurations. They have larger wheels, wider tires. If you look again at Exhibit D, the aerial photo, and you look
Hold on. Let me pull that up before you. I'm sorry, that was Exhibit D?
That's correct.
All right. I see that.
That's an aerial photo of the Loud property, and you can see that the crops, corn that they harvested is gone. And if you were expecting farm equipment to cause ruts or dig down into the soil because of the weight, you'd expect to see tracks paralleling the corn all the way across the field. You don't see that. All you see are the wheel pathways of the heavy trucks. So the farm equipment has a different configuration in terms of the weight impact.
I got you. Where, as I look at this Exhibit D, where is the pipeline?
Your Honor, if you look in the lower kind of left-hand corner, there's a wood lot edge, the edge of the woods. The pipeline is paralleling that. And then if you see there's a white pickup truck, and a little bit further up the picture to the right is the air bridge under construction. So the pipeline runs under that and continues to the top of the page straight across the property.
So who's building this air bridge?
Well, Trine was requested to put it in and they refused. Panhandle felt that the continuing traffic would endanger the pipelines, so they went out and put it in themselves to mitigate the damages.
So if the logging trucks utilize this air bridge, would that alleviate any concern for damage to the pipeline?
It would, on a temporary basis, yes, Your Honor.
What do you mean on a temporary basis?
Well, we don't want to leave that air bridge there forever.
I got you. No, that's what I get that. If the air bridge is not there and they drive trucks over it, it could cause damage. But as long as they use the air bridge, the concern is alleviated.
It's mitigated, yes, Your Honor, if they use it.
Wouldn't the simple way that I resolve this preliminary injunction issue just to say that the logging trucks have to utilize the air bridge?
Yes, Your Honor.
And I can decide at a future date whether or not there ought to be liability of the landowner or the logging company for the cost of constructing that. That's just an issue of damages.
That's
but
correct.
As long as you've already acted to put the bridge in, and the bridge, if utilized, if I simply issued a preliminary injunction that says the logging trucks must utilize this bridge when crossing the pipeline, doesn't that resolve things, at least in terms for emergency concerns?
At the preliminary injunction stage, yes, it does, Your Honor.
And was that you, Mr. Horn? I'm sorry, I'm looking at the video, so I couldn't tell who was talking, or the
Yes, that
photograph.
was me. It would, at this stage for the preliminary injunction, that would resolve the existing concern so long as they do use it. And when logging is done, then we will remove it. But we need to know when they're going to be done.
Okay, Mr. Dunlap, at least for purposes of the preliminary injunction, and I'm not in any way suggesting that I don't appreciate the arguments you've raised with respect to the language of the easement, but the simple reality is, for purpose of emergency relief, as long as your clients utilize the air bridge, that alleviates the concern. There's no cost to them for doing that. There might be someday. We'd have to decide that at a later date. I can't really address that today, but I don't think I need to for purposes of making sure that the pipeline is safe.
Absolutely. What the initial issue.
We're not getting your audio, Mr. Dunlap. I don't know why.
Can you hear me now, Your Honor?
Just barely. It's very, very weak. Adjust your volume.
I'm going to try to do that. Can you hear me now at all or no? Could you hear me earlier?
I can barely hear you, but I'm sure our recording system is not picking you up.
Wow. I don't know. Because it was working earlier, I believe, wasn't it?
I'm-
Working earlier?
There should be audio controls for me on my Zoom screen. It's the lower left-hand corner of the Zoom window.
Yeah. I don't have
If you click on that arrow and then click audio settings, it allows you to adjust the volume on your microphone.
Is that better, Your Honor?
Oh, much better. Thank you.
Okay. Yeah, I just turned it to max. I don't know why it was automatically at another level. Thank you, Your Honor. And I appreciate you wanting to hear me. So I know you have a lot of emotions this morning. However, I think that the judge is cutting right to the chase. I think that right now, and it took a lot of work for these parties to get to the point of actually having the air bridge constructed. But I don't have a problem if the preliminary injunction is limited to the use of the air bridge for logging and that there is no further restrictions on the cultivating of the property at this time. Obviously, the cost is something to be looked at later, and we can present our proofs if Mr. Horn and I cannot come to an agreement on that particular issue. But I do think that I think that that deals with the immediate concern. So, and I see that Mr. Trine is here. So if Trine agrees that any further logging that goes on between now and I don't know, the next however long it takes for them to finish it will be done over that air bridge. All semi trucks. You're referring to semi trucks only, is that right, Mr. Horn? Not skidders or anything else?
Semi trucks or heavy equipment.
Okay. And I don't know what type of equipment is being used there. And my clients, of course, my clients are property owners. They're not loggers. They don't know what needs to be used to try to go across this property. But I do think that if they're using the air bridge for, what other heavy equipment would you think would be needed other than the semis? What would your other concern be? Maybe Mr. Cloud knows.
Well,
Yes,
I think to be safe, they should just use the air bridge for all of their equipment. There's no increased difficulty in driving over it.
Mr. Trine, is that something that you're aware of? Because you're the logger. I don't know what is used there.
Can you guys hear me?
Yes.
Yes. We have absolutely used the air bridge every single time we've went since they installed it. The air bridge has been used the whole time. Empty trucks, loaded trucks, any equipment have went across the air bridge. We have been utilizing the air bridge, and that is not an issue whatsoever. I was very cooperative with them when they installed the air bridge. We've used it. I helped them install the air bridge, and I've used it ever since it's been installed. So that's not an issue to me whatsoever. I'm 100% okay with that. It does not cause any issues.
All right, let me stop everyone. Okay, I lost my audio connection, just as you, Mr. Dunlap, were about to ask Mr. Trine what other heavy equipment there is. From that point on, I didn't hear a thing.
Okay, all right, I will turn it back over to Mr. Trine because I think your honor has got right to the issue here. Go ahead, Mr. Trine, and repeat what you indicated earlier off the record.
Yeah. As soon as we installed the air bridge, we have used that air bridge absolutely every time crossing loaded trucks, unloaded trucks, any heavy equipment. We have used the air bridge. I helped them install the air bridge, and we got it put to where I thought it needed to be put to make sure the job would go as smoothly as possible. And we have used the air bridge ever since it's been installed. Absolutely, and it's causing us no issue whatsoever.
Wonderful. So why don't I just issue a preliminary injunction that says that the logging operation that's taking place, all heavy equipment must utilize the air bridge when crossing the pipeline. And that should resolve things for today, shouldn't it, gentlemen?
Yes, Your Honor. Just one question. We'd like to have an idea of when this logging may end.
Mr. Trine, do you have a handle on that?
Yes, we are hoping to have it, but there's only 4 loads of logs left. So I'm hoping to have it done possibly tomorrow, depending on the weather. We would have had it done by now, except for we got the rain last weekend. So it's just weather issue, but there's only 4 loads of logs left, and I have trucks hauling today. So possibly be done tomorrow. And I told one of the Panhandle representatives, as soon as I'm done, as soon as I know I'm done, I will absolutely text him or call him and let him know so they knew that they could remove the bridge. So yes, as soon as I'm hoping tomorrow, but I can't promise depending on the weather and if anything happened, but there's only 4 loads of logs left and we will be done with the job.
Do you have it done by the 10th of December, Mr. Trine, for sure?
Absolutely.
Okay, would that be okay with you, Mr. Horn, if we just use that as a date and then made that part of the order, and then we decide what we do with the air bridge and the cost and everything else? If we can agree, we do. If we don't, we don't.
I agree that the issue of the cost we can work on later. December 10th would be a good end date if it's done sooner. If Mr. Trine could let us know. There are costs incurred on a daily basis for the air bridge, so we would remove it as soon as they're done.
Okay. All right, and then
Wonderful.
We will let you know as soon as it's done. Mr. Trine, can you let us know and let Panhandle know when you're done so that they can remove the air bridge?
Absolutely. I will let Mr. Gray know so he can let the Loud family know, and I will let the Panhandle representative know as well.
Awesome.
Mr. Trine, would you let Nathan Cloud as the Panhandle representative know?
Sure. I believe Frank is the only one I have been talking with on a more of a daily basis, but if my phone number, if he would give my phone number to Nathan, Nathan's number, and I can absolutely contact Nathan as well.
You know what? We're having a hard time hearing you, but Mr. Cloud, can you give us your telephone number, contact? Do you have any problem doing that so he can contact you and we all have it if we need it?
Yep, not a problem. It's my cell phone number is 1-317-672-8725.
Okay, so we'll use as a contact. Mr. Gray and myself have that number as well as Mr. Trine. If not, we'll make sure we have that. And we want to keep the costs at a minimum. We've always wanted to have a minimum impact on this. We just own the property. We don't log. We have somebody else leasing out there. So if this works out, I'm fine with that for right now, Your Honor.
Wonderful. You may submit your order to that effect. And if it's even necessary, it sounds like it's all, by the time you get an order to me and get it signed, it sounds like he's going to be done. But in any event, it sounds like Mr. Trine is cooperating fully, and I'm glad to hear that.
Can you prepare a proposed order, Mr. Horn, and send that to me? I'm trying to keep my client's costs down as much as I can here.
I will do so.
All right.
All right. Thank you all. Have a good day. Be safe.
Thank you so much. Thank you, everyone.
Thank you, Your Honor.
Take care. Thank you, Your Honor.
Thank you.
Okay, let's see, Mr. Carroll, you're here on
Morning.
Hirschberger.
Remember, Judge,
Is
we
that right?
kicked this over a little bit because we were a little bit before the 60 days with the default judgment of divorce, and you wanted to wait that. We already took proofs the last time we were on the record. So you should just have the default judgment of divorce that I'd ask the court to sign.
Well, let me see if I can find it. Give me just a moment here.
Your Honor, is his client here?
No,
No, okay.
No, I didn't have him come in because he already took the proofs.
all right, well, I don't, oh, is this it?
No, it's just
Cool. Is it possible for you to email that to Peter?
Absolutely.
And I can
Sam,
sign
can
it?
we email that JOD on Hirschberger again? Who do you want me to send it to, Judge?
Send it to P. Veldkamp.
P. Bellkamp?
P as in Peter, V as in Victor, ELD, KAMP at mijackson.org.
So I've got P as in Peter, VELD, KAMP at Michigan Jackson. Oh, that's odd.
No,
At Michigan
no
dot
dot.
Jackson?
No
Oh, at Michigan
dot.
Jackson. Okay.
At mijackson.org.
Okay. All right. Correct, Sam. All right. We are sending it to you right now.
All right.
And I never, air bridges are the best example of what you see with consumers' energy. They use them in swamps mostly. Those huge, they're probably 8x8 logs. Sometimes they're 10x10s, and they just lay them basically across muck or swampy stuff so they can operate heavy equipment. It almost floats, really.
One of the routes that I take traveling back and forth to Munising, there's actually 3 ways you can go, and they're almost the same length. But one of them, they were putting in a new power line over the course of several months, and it was clearly marshy area, and they had those air bridges laid down all along the route, and they would pick them up at one point and then move it down to the next one. I think that stretches about 17 miles along the entire route. When I first saw the logs piled up, I'm wondering what in the world is going on. And then finally I saw the new power lines going up and realized in order to get the equipment in place to drive these very large telephone poles down into the ground, they needed a stable surface to sit on. And that's exactly what they used.
Yeah, no, it's kind of like if you wanted to roll something into your backyard, you'd have a bunch of round timber, or like a roller system, and take the one from the back, put it up front, and just keep going. It takes a lot of time, but that's they don't mind that. Time is money.
It's a lot less time than trying to get one of those huge pieces unstuck from the muck.
Oh, I don't know if they get those out. I represent Jimmy's, and I know that they make a lot of money off of consumers getting stuff out of the mud.
All right, I have your default judgment. And I am signing it now.
Thank you very much, Judge.
You're welcome. Have a good day, Sean.
All right, you too. Take care. See you later, Shannon.
Bye, Sean.